Thank you, ladies and gentlemen, for this opportunity. Following the conversation this morning, I noticed a lot of concerns regarding the laws in Cameroon. And I just want to point out that if we are being cheated this much with all the laws that are affecting us, just think about it. As a woman, you are being cheated twice. So today, I am going to be attempting to tell you why I say so. And this is just a journey. It is the beginning. I just came back from Cameroon. And believe me, my sisters back there are realizing the need to come out and voice the concerns of the issues that they also encounter as women in Cameroon. I will introduce, just like in many other countries throughout the world, Cameroonian women continue to suffer numerous injustices, generally deriving from the discriminative nature of the laws that govern the people. In Cameroon, although the highest governing law of the country, the Constitution in its preamble, guarantees that all human beings, without the distinction of race, religion, and sex, possess inalienable rights, there continue to exist an overt discrimination against women. As a result, the cultural and religious foundation of the people establishes a clear-cut hierarchy between men and women, restricting men and women from sharing the same privileges, especially with regards to customary matters. Consequently, customary law, which strongly discriminates against women, has silently taken precedence over many statutory laws. Despite this, the current government, in its more than 25 years in power, has been inefficient in establishing a culture of gender equality in the country. As a result, several statutory and customary laws which discriminate against women, as well as traditional practices which violate the rights of women and girls, remain acceptable and duly enforced by the courts, despite other legislative enactment to the contrary. Women continue to be deprived of opportunities to empower and liberate themselves from their constant dependency on men, as has been the case for several generations now. Even though the Southern Cameroon High Court's law of 1955 promised to fulfill and respect every customary and native law, provided that it complied with natural justice, equity, and good conscience, it is regrettable that there still exist discriminatory practices in Cameroon which violate the rights of women today. Even though Cameroonian courts hold that any custom which states that a woman or any other human being is property that can be inherited is repugnant to natural justice, equity, and good conscience, the government has failed to establish a human rights culture, especially with regards to traditional customs that discriminate against women. Traditional authorities are yet to understand that treating women as practically non-person or second-class citizen is unlawful. Since there is no specific law in place that prohibits any form of discrimination against women, it is only fair to state that there is no schism between both statutory and customary law when it comes to women's rights. According to the Human Rights Fourth Periodic Report for Cameroon, the Cameroonian legislature and court do not adopt or apply laws and practices aimed at fostering gender inequalities and promoting male domination. However, this is not true, because the Cameroonian legislature has demonstrated in many situations that its laws are flawed, biased, and discriminatory towards women. And I'll tell you why. The Civil Status Registration Ordinance of 1981, which is the law that governs the civil status in Cameroon, with regards to marriage, in Article 49 of this ordinance, legally recognizes polygamy as a statutory form of marriage. By so doing, the legislator underlooks the demeaning effect that this form of marriage sometimes has on women and even more on the children that are nurtured into these homes. In addition, Article 52 of the same ordinance establishes the legal age for a person to enter into a valid marriage. Curiously, it is observed that while the legal age for a boy to contract a marriage, a valid marriage, is set at 18, that of a girl is regrettably set at 15. And this brings me to wonder why. The girl child is allowed to marry 3 years earlier than her male counterpart. And even more despicable, Section 356 of the Penal Code further accentuates this by stating that it is a crime for a boy under the age of 16 to be given to marriage, but reduces the punishment for the girl to enter into marriage to 14 years. This means that while a male child is allowed ample time to mature and finish high school, a female child is simply nurtured enough to attain the childbearing age and then offered to become another person's property. At a tender age when most girls are still dependent on their parents for welfare, the girls are allowed to marry and become parents when they can barely care for themselves. As a result, they remain vulnerable to being exploited and manipulated by men who take the opportunity of their youthfulness, innocence, illiteracy as a tool to dominate and suppress them. Henceforth, their spouses become their mouthpieces, whenever these young wives are given the opportunity to express their opinion, they often align behind their men, even when they may not agree with an issue. Fear and failure to comply may lead to serious reprimand or even battery. And this takes me to the next point, battery and domestic violence. Rape first. Even though rape is a criminal offense punishable with a penalty of between 5 to 10 years imprisonment, many cases of rape unfortunately go unreported because of the local taboo of sexual violence. Despicably, Section 297 of the Penal Code, in quote, allows the rapist to expunge his offense by marrying the woman he raped. Hence, a rapist is no longer considered a rapist if he chooses to marry his victim, since once both parties agreed to marriage, then civil law has been satisfied. Why is the rapist given an opportunity to purchase his freedom? Even though the law demands that there should be a free consent of the parties in marriage, I believe in this instance the consent is bogus, since it is given after the offense has taken place. Is this marriage considered consensual, even though the act that led to its occurrence was non-consensual? Shouldn't we instead condemn this as repugnant to natural justice? Instead of penalizing the rapist, the legislator again provides avenues for men to overcome punishment, leaving the women to endure the agony and the stigma of being known in the community as a rape victim. Although local authorities argue that the rape followed by marriage is not an obligation, I think it should not even be an option. A criminal act has been committed, and the perpetrator has to assume the consequences of his actions if found guilty. With regards to matters of domestic violence, wife beating in Cameroon is not reported, and moreover, wife beating is permitted. Consequently, due to the patriarchal nature of our Cameroonian culture, most battling males have acquired very rigid views of gender roles. Consequently, this influences their attitude towards women, as they see women in disrespectful and objectified ways. As a result, a man beating his wife is usually regarded as a form of correction, since it is customary right for women to be corrected by their husbands when they disobey them. Intriguingly, some women find it acceptable to be beaten by their husband, and battery is even considered to be some sort of chastisement in some local Cameroonian custom. It is believed that a man beats his wife to show that he loves and cares for her. In this beating, he is simply correcting her for a mistake to stop it from repeating itself. Unfortunately, the prevalence of domestic violence is emblematic of the low status of women in Cameroon. Because women are perceived as immature and foolish, men have the responsibility to guide them with beating if deemed necessary. Ironically, more local women are likely to justify white beating in situations of burning the food, neglecting the children, arguing with a husband, leaving the house without permission, or even refusing to have sex after suspecting him of having an extramarital affair. This acceptance of domestic violence is explained by the socio-cultural practice that subjugate the position of women in the society. Another point that I would want to talk about is the matters of paternity and adultery. You will be surprised to realize that in Cameroon, and this is the law, a woman who has a child out of wedlock has a limited time period of 60 days within which she has to begin paternity action for her child, or else her child will be known as fatherless, or what is commonly known as père inconnu. However, the man can begin paternity action for his child born out of wedlock anytime he wishes to do so, if he so wishes to do so. And moreover, more also, the woman may be denied to even begin action if it is proven that she had any other relationship with another man during the time she conceived this child. In matters of adultery, and I would read as I copied from the Civil Status Registration Ordinance of 1981. In section 361 of the Cameroonian Penal Code, any married woman who has sexual intercourse with another man shall be punished. But any married man who has sexual intercourse in his matrimonial home or has sex habitually elsewhere shall be punished. What does this mean? Regardless, if you are a woman and you have sexual intercourse with another man, you are punished. But if you are a man, the act must have taken place in your matrimonial home, and this act must have been happening regularly for it to be punished. It is not me, it is the law. Regardless. And I ask the questions, why a double standard for the same offense? Are men more susceptible to become adulterers, thus protected? Regardless, the law should punish offenders equitably. And again, recently I went to Cameroon, and just by coincidence on the day I was arriving, I heard it was declared, it was June 20th, International Day of the Widow. And I asked, why an International Day for the widow when we just had an International Day for women? And this reminded me of the issues of succession law I had studied at school and the things that I had experienced with succession and inheritance in Cameroon. Widows in Cameroon have been given a day where to recognize that they undergo serious disinheritance after their husband dies. They are trying to protect the widows now because the government has realized there is a problem. In conclusion, I want to call on my fellow brothers to join us. Human rights and gender equality should not be a woman issue. It should be our issue, because we have to be mindful that we are human beings, created in God's image and likeness. We didn't ask to be women. We just want our own share of God's creation. And I read a really interesting statement. So I will conclude with a statement from Women Action, which is word and deed, holding government accountable in the Beijing +10 review process. And it says, in quote, "Law is the most formal expression of government policy. A government that allows discriminatory laws to remain in force endorses and promotes inequality. Without equality under the law, women have no recourse when they face discrimination that affects all aspects of their lives. The fact that there are many laws, in fact, so many laws, that explicitly discriminate against women, nearly 10 years after the Beijing Platform of Action, and 55 years after the adoption of the Universal Declaration of Human Rights, is unacceptable." And I will conclude with that, my brothers and sisters. It is time to start making some noise and just reflecting on some of these laws that truly exist in Cameroon today that somehow hinders the development of women. Thank you.